A critical part of any estate plan is planning for incapacity because of a health issue. Usually that means an advanced healthcare directive, which is a healthcare power of attorney and a living will. But that really deals with medical treatment, probably in a hospital. What kinds of treatment will you get for bodily illnesses that happen and you're unable to speak for yourself? But what about mental illness? Is there any sort of planning that should be done there? My name is Patrick Cawley, and I am an estate planning and elder law attorney with Keystone Elder Law in Mechanicsburg, Pennsylvania. And Pennsylvania law does set forth specific kinds of planning that you can do and should do if you have either a history of having episodes of mental illness, or maybe you have a family history, something you haven't experienced yet, but you want to plan for. So that type of planning comes in two different forms. One, there's a declaration where if you do have personal experience going through an episode of mental illness, you can set forth your preferences, whether it's you really liked care that you received in a certain facility and you would prefer that be the facility that cares for you should there be a future episode of mental illness, or you can say, I don't want to go to a particular facility. This also extends into specific kinds of treatment. Maybe there's a medication that's clinically appropriate, but in your experience it caused you side effects that you're uncomfortable with, and you would prefer not to have that medication as part of your treatment plan. So the declaration is where you can state specific preferences that you have for treatment in the event of an episode of mental illness. Maybe you don't have any experience with it before, you just know that there's a family history and you want some planning in place in case it happens to you, that you're having an episode of mental illness, and that's fine. Then I would recommend that you rely more heavily on the mental health power of attorney. So just like a power of attorney for financial decisions or medical decisions in the hospital, there is a power of attorney just for mental health issues where you can designate a person you trust to make decisions for you and to consult with your psychiatrist or your psychologist or whoever else is providing the care and come up with decisions made on your behalf when you are unable to make rational decisions for yourself. And they can be combined, the declaration and the mental health power of attorney, into one document that really covers everything to have decisions made for you that you are comfortable with. You can make that planning as long as you are not in the throes of an episode of mental illness. You can sit down and make that planning and be prepared for when it comes your way. One other thing to keep in mind, the mental health power of attorney and the declaration are good for 2 years. So unlike other types of documents where you can make your plans and then sit back for several years before there's any reason to change them, you do need to update these documents once every 2 years. And if you are in the middle of an episode of mental illness when that 2-year time comes up, it will continue to be valid until you are able to have the cognitive capacity and the mental health to make a new plan. But you do need to keep that 2-year window in mind. And the other thing is, once you're finished coming up with one of these mental health estate planning techniques, you want to provide the documentation to your physician, to any sort of existing psychiatrist or psychologist who's treating you, so that they know of the plan and they know of your preferences. If you have any questions about this, please reach out. Shoot me an email at info@keystoneelderlaw.com.